Welcome, welcome. Welcome to you, Free Law School. Going to talk to entrepreneurs about business structure. Does your business support or does your structure still support the business you've built? That's the conversation we've been having. Does your business structure still support the business you've built? My name is Gregory Swafford, the host of Free Law School, and that's the conversation we're going to have. Maybe you're operating the business already, growing the business and the structure you started out with. Maybe you haven't revisited that structure. Maybe you're still operating with the same structure that you had from the beginning. We're going to get into it. We're going to talk about that. Let's get some other folks here into the conversation. And is your name still on everything? Is your name still on everything? Or did you put the separation into effect? Did you separate yourself from your business? Is there a separation between you and the business entity? We're going to answer some of those questions. We're going to get into it. We're going to talk about the purpose behind forming a business entity or not, whether it makes sense for you now starting out to form your LLC or corporation, or whether it makes sense to operate as a sole proprietor. Many people do. We're going to talk about the pros and cons of operating as a sole proprietor. That's our conversation for tonight. We're going to talk about limited liability protection. What's it all about? What's the purpose? What is the purpose behind limited liability protection? Why do we form? Why do we even form a business entity? Is it necessary? Here's a question for you, and thank you for joining. Here's a question. If your business was sued today, what could they actually take from you? Drop it in the chat. If your business was sued today, what could they actually take from you? Put it in the chat. Let me know where you're joining from, what your business industry is. I don't know what that's about. This is not the way, but we'll get into it. Put it in the chat. Let me know where you're joining from and what your industry is. What's your business industry? And whether you have an LLC or a corporation. This is your opportunity to get your questions answered. If you've ever had business structure questions and couldn't get a straight answer on them, now is the time. Drop it in the chat. The purpose behind limited liability protection is to separate your personal assets from the business liability. That's why we form. That's the protection that's afforded. Now, many business owners misconstrue what that means. There's a lot of misunderstanding surrounding exactly what that means. Many business owners believe that forming the LLC, i.e., get an LLC, get an EIN number, and open a bank account, solves all of the problems. That is actually business structure. That's just the formation. That means that those business owners have performed the minimum necessary requirements to be recognized by the system. It doesn't mean that there's protection. Limited liability protection is conditional, and it's not conditioned upon formation. I know many business owners think that forming the entity, getting the paperwork, they're good. They go out to these commercial outfits, LegalZoom, Rocket Lawyer, Taylor Brands, whoever you decide to engage with. They go out, they secure the articles of organization, and they believe that that is structure, that provides protection. That's just paperwork. Paperwork does not provide protection. Paperwork is simply a receipt. That's all it is. It just means that you have been recognized by the system. Now, whether or not that recognition will eventually turn into limited liability protection when it's tested, when it's needed, is dependent upon how you operate the business. That's what the protection is conditioned upon. Now, for purposes of our conversation, limited liability protection means the same thing no matter whether we're operating a corporation or whether we're operating a limited liability company. It means the same thing. The limited liability protection means the same thing. And the maintenance of it is done in the same way. And here's what I mean by that. There must be a separation between control and ownership. That's key. Ownership is not control. And that's one of the greatest misconceptions held by business owners. That ownership and control is the same thing. Because I own it, I get to say and control it. That's very possible. And from an operational standpoint, it happens every day. But we still have to maintain the separation between our personal lives and our business capacity. And that's done by things like not mixing personal expenses with business expenses. You may have heard of the term before, commingling. Commingling is a very common occurrence and will cause you to lose your shield or corporate veil very quickly. Mixing personal expenses with business expenses, or paying your personal expenses out of business funds. And here's one of the ways that happens. Business owners, entrepreneurs, many operate from the standpoint that because they are single member LLCs or the sole owner in the LLC, that they can move money at will, however they choose. But if you take funds out of your business account by using your business checking card or business debit card and pay personal expenses, that's commingling. There's no documentation. If you're going to take a draw, then you need to transfer those funds out of the business account and into the separate account. Into your separate personal account, documenting the transfer so that if and when it's ever questioned, there is documentation of separation. Another way in which separation is evidenced, or the lack thereof, is how we sign contracts, whether or not you sign those in your personal name or whether you sign them in a representative capacity. And what I mean by representative capacity is, do you sign as John James, period, or as John James, manager for XYZ LLC? That's signing in a representative capacity. That's letting everyone know clearly that you're doing business with, that you are not taking on the obligation in your personal capacity, that the business, the LLC, is responsible for the obligation, for satisfying the obligation. Here's another one. Business owners acting as a personal guarantor for business debt. If you sign as a guarantor, personal guarantee, if you sign as a guarantor for the business, you sacrifice your limited liability protection, at least as it relates to that debt. If there is a default on the debt, there will be no limited liability protection. You will be personally responsible for that debt. And there's a lot of misunderstanding and misconceptions about how that works. The personal guarantee pretty much eviscerates the limited liability protection, eliminates it, the limited liability protection, immediately upon signing. So the entrepreneur, operator, you have to be very mindful. That needs to be a conscious decision. I get it. I understand. I've represented business owners, entrepreneurs for over 30 years. And I understand that many times, particularly in startups, the owner, operator, steps in and guarantees the business debt. It happens. But we need to understand what we're compromising when it's done. Because many business owners, I've seen it many times, find themselves in trouble as it relates to the debt. And if and when a lawsuit is filed on the debt and a judgment is rendered, they're taken back by the fact that now those personal assets are at risk because there is no shield as it relates to that debt or limited liability protection. It's gone. So if we're gonna make those kind of compromises, it's very important that we understand that those are conscious moves, not something that we're gonna find out on the back end that it's a problem. Now, if you're just joining us, welcome to Free Law School. I'm your host, Gregory Swafford. Put it in the chat. Let us know where you're joining from and what your industry is. Whether if you're operating a business right now, what's your industry? We're talking about having a conversation about limited liability protection. What's the purpose of it? How does it operate? The purpose is to protect your personal assets from business liability. Now, many business owners think that merely forming the business, getting the paperwork in their hands, means protection, means business structure. Nothing could be further from the truth. The paperwork is merely a receipt. The limited liability company that's created is a container. And that container is going to hold all of your business transactions going forward. And at some point, those transactions are going to be interpreted in order to determine whether or not there is separation between you personally and your business. Now, that usually comes up in any number of circumstances. Any number of institutions can test your business structure at any given time. All of those transactions from day one, signing a lease. Well, did you sign the lease in your personal capacity? Did you act as guarantor for the company? Bank loan. Were you the personal guarantor for the loan? Contracts with vendors. How did you sign those vendor contracts? Did you sign in your personal capacity or did you sign as manager of the LLC in your representative capacity? Each and every one of those transactions sends out a signal. From day one, you begin sending out signals as you enter into those transactions. And most business owners are totally oblivious as to the sending of those signals, and that at some point in the future, those things are going to be looked at and interpreted to determine who controls the business, where does the authority lie in the business, whether there's continuity in the business, who steps up in the gap when things go sideways. Those are the types of questions that are going to be asked and interpreted by institutions during what we call pressure events. Now, most business owners think that pressure events means strictly litigation, but it's not solely litigation. There are any number of institutions who are interested in those signals that are being sent out. Banks are interested. Real estate underwriters, insurance underwriters, when we seek to insure business assets. If we're taking on investors, the investor doing his or her due diligence, they're interested in those signals. Auditors, all of those institutions have their own procedures and way of looking at things and interpreting those signals, but they all share one thing in common. They're all trying to get to the bottom of whether or not and this is important, the courts included, especially the courts, they're all trying to get to the bottom of whether or not the business operates independently of the owner. The court wants to know whether the business operates independently of the owner to determine whether or not the liability is going to stop at the door of the business or whether the liability is going to proceed straight through that door and over to the owner operator personally. The bank wants to know, does the business operate independently of the owner? Because it's going to weigh in on what terms are offered for the loan, or whether or not the loan is going to be even extended at all. Insurance underwriters want to know, how are the properties titled? Who owns them? All different purposes, but they're all looking at the same thing and trying to arrive at the same bottom line. Now, you can operate a business. I asked a question early. If your business was sued today, what could they take from you? Think about that for a minute. If your business was sued today, what could they actually take from you? And most owner, operators, entrepreneurs immediately say, nothing. I'm good. I have my paperwork. I file my annual report on time. I pay my franchise taxes or fees or whatever they're called in your jurisdiction on time. I'm good. That answers the question of compliance. Compliance and protection are two separate things. Compliance, again, means simply that you've performed the minimum requirements necessary to be recognized by the system. It does not address the question of what happens when things go sideways or when things go wrong. That's the protection question. And so you can file your reports on time, pay your taxes on time, and still be totally exposed. From a personal standpoint, and the exposure arises from your operational behavior. Now, many business owners think that business structure, that this conversation is a legal conversation, but it's not. Business structure is not legal at all. Business structure is behavioral, because each of those institutions, the court included, is looking at how the business operates. Who had the final decision? Who stepped up when problems escalated and resolved things? Who stood to benefit financially from the activity in the business? They're all looking at behavior. The bank, they're looking behind the curtain. When you have accounts at that financial institution, when you're applying for a loan, they're not just asking for P&Ls and tax returns and bank statements just to see if you can produce documents. They're piecing together your financial behavior. That's what they're looking at. And if you bank at that financial institution, they get the behind the curtains look at what your financial behavior looks like. Because they can see immediately whether or not the business generates revenue sufficient to operate independently, or whether or not the owner injects personal cash into the business to keep it propped up. They can see that. And if they make that determination, they may ask for a personal guarantee. Interest rate may be a little higher. The term for repayment may be a little shorter. That window may be a little smaller. Or maybe they decide not to extend credit at all. Behavioral. Business structure is behavioral. It only becomes legal when there's a conflict. It only becomes legal when there is a conflict. Now, I get it. Legal conflicts, lawsuits, it's always been the elephant in the room. But there are many other instances in which that behavior is being observed. Now that we understand that limited liability protection is not automatic, it's conditional, and it's conditional upon how we operate the business, there's the other side to it. And here's where another one of the great misconceptions held by business owners. And that is in thinking that everything that we place inside that business is protected by that limited liability company, by that LLC that we formed. Here's the news flash. If you have cash reserves, maybe you made money and that money is sitting in that LLC account. Maybe you own real estate in the name of the LLC. Maybe you have trademarks and your brand, your company brand, all inside that LLC, contracts, business equipment, transportation equipment. None of those assets are protected. The limited liability company does not protect business assets from business liability. It doesn't protect assets from itself. For my operators, for those of you who are operating a business right now and you have the LLC and you have all of your valuable business assets inside that LLC, one lawsuit, depending upon the amount and size of the judgment, could wipe it all out. None of those assets are protected. Why? Because that's not the function of the limited liability company. Your limited liability company, that LLC that you have, that is your operating company. You have effectively placed all of your valuable assets inside of your operating company where all of the daily risk lives. That's where you sign contracts. That's where you hire employees. That's where you deal with vendors, customers. That's your public-facing entity. That's where all of the risk lives. I'll tell you a story. I had a client, and client was in the construction business for many years. And like many people, we have a tendency to put things off, particularly when revenue is growing year over year. It has a tendency to provide a false sense of security. When business owners are making money, they have a tendency to believe that everything is all right. Otherwise, they wouldn't be making money. How could I be making money and be exposed? But growth masks exposure, because business structure is only tested during pressure events. That's the only time that you know. If nobody's knocking on the door from the bank or the underwriters or the auditors or the court, there's no reason to believe that everything is not all right. So this client, and the individual had been a client on another occasion, but when this event arose, client got sued, and there were two claims. Two plaintiffs. And he was covered in insurance. And the insurance company tendered the policy limits on the first judgment. It was $500,000. They tendered the policy limits. And then, so the client calls me up because my office is not representing him because he's got insurance. So for you guys who are aware, and you know that the main purpose of insurance, one of the main purposes of insurance is to provide you with a defense, right? So they provided him with lawyers and a defense. In that instance, they tendered the policy limits. Now, here comes the second claim, which had not yet proceeded to judgment. And the estimation was that this judgment was going to come in somewhere in the neighborhood of $300,000. So now he's in a panic because there are no more insurance proceeds. Now that money has to come from the business and or him personally. So he reaches out and he wants to know, what can I do? How can I fix this at this point? I don't want to lose my home. I don't want to lose my things that I have. I don't want to have to start selling things off. Can I move some things around now? Can I move my assets around now? Can I structure? Can I do those things that you'd been telling me about all these? And the answer was, unfortunately, no. And it was not because I held some kind of ethical high ground or anything like that, or felt some kind of way because he hadn't executed it earlier. It's the same thing that any lawyer will tell you. And that is that once the lawsuits are filed, claims made, demand letters crossing, debt defaults. You can't move the property. That's called a fraudulent transfer. Those are called fraudulent transfers, and the courts will unwind those transactions, bring it back, impose fines, and depending upon the circumstances, you could even be faced with criminal penalties. So the time to put the structure in place is before you have a problem. And for many business owners, because it's so easy to void your protection, and in many instances never even gain the protection for many business owners because they begin operating improperly from the beginning. Knowledge is power. That's why we have these conversations. That's the purpose of Free Law School, the mission. Many business owners have absolutely no protection. They just don't know it yet because they haven't been tested yet. They're operating the business improperly. Therefore, the limited liability protection afforded to their personal assets is non-existent. And if all you have is that operating LLC, all of your business assets are exposed. Think about that for a minute. You're out there operating, thinking about scaling. You want to do another location, and you might not even have any protection. You're also scaling the potential for liability. And that's why we talk about layered protection and the holding company, first and foremost. Okay? We talk about the holding company because many business owners are not even aware of the need for the holding company or what the purpose of the holding company is. If you know, if you're familiar with that concept, with the concept of the holding company, put it in the chat. You got to put something in the chat, guys. This is not Netflix. You can't just sit here and watch me. I'm not a paid actor. Put it in the chat. Let me know if you're familiar with the concept of the holding company. And we're going to get into it and talk about what it is, how it operates. It's the purpose of the holding company. And a lot of the meaning is there in the name, the holding company. The purpose is to hold your valuable business assets. That's the purpose. It's synonymous with parent company. Same thing. Same thing. It's synonymous with the parent company. But here's the thing. It does not do business. It has no clients. It doesn't sign contracts. It doesn't sell any products or services. It simply holds the valuable business assets of the operating company, so that if there is a claim which results in a lawsuit, which then results in a judgment being rendered against the LLC, well, those valuable assets, the trademarks, the cash reserves, the real estate, the business equipment, none of those things can be seized because they're not owned by the company that caused the harm. That's the way our legal system works, right? Legal system says that the entity that caused the harm is responsible for making the injured party whole. So the operating LLC is doing the business. And the delivery driver of the operating LLC gets into an auto accident, causes injury. Insurance company pays the limits, but there is an amount in excess of the policy. So now the business, the operating company, is responsible for that payment of the excess amount. But the operating company doesn't own anything substantial. The operating company only has enough money to pay its bills, to pay all of its expenses. It owns nothing. It doesn't own the trademark. It doesn't own the building that it operates from. It doesn't even own the vans that the delivery driver was driving. So therefore, the party who sued, the plaintiff, the judgment creditor is what it's called, a person who sues and wins a judgment is called the judgment creditor, right? So the judgment creditor, there's nothing to collect on because the operating LLC owns nothing of value. All of those valuable assets are owned by the holding company, the parent company. That's how we keep those assets out of harm's way. That's the way the system is designed to operate from the beginning of time. There's nothing nefarious about it. We're not hiding anything. We're not playing shell game. None of that. The only thing that the entrepreneur, founder, operator stands to lose is that LLC. It gets dissolved and you form another one, but those assets that you use to deliver the goods and services are still intact, unaffected. Now, there's another layer, and that's the trust layer. And the trust layer sits above the holding company. That's when we talk about own nothing, control everything. Those three layers work together. And I know, many business owners, we talk about paperwork and receipts, and thinking that we can just run out and we can grab some paperwork and that solves everything. Well, we talked earlier about business structure being behavioral. It's how the business operates, how you move. And when we're talking about the totality of the structure, the trust, holding company, operating company, we're really talking about the relationships between those three entities. And that's what business structure is. It's behavioral, and those relationships between the three entities. And when we find ourselves being tested, let's say in court, when we find ourselves defending the corporate shield, those are the type of questions also that's going to be asked. Questions that weigh on the relationships, particularly between the holding company and the operating company. That's what we're talking about. That's what we're talking about when we have the conversations about business structure and limited liability protection. Look, guys, everybody wants to make money. Everybody wants to make money. I've seen it many times over the years. We skip the legal part. And I have to say that these conversations are for educational purposes only. They're not meant to start an attorney-client relationship, nor in fact do they establish an attorney-client relationship. But many business owners skip this part of their understanding. You'll put together a business plan and apply for this or do that, or take your savings to invest in the business. It's very important that you understand how to operate and setting up a business structure properly from the beginning. Now, when you set it up from the beginning, it doesn't mean that you're not going to revisit it. That's another one of the common mistakes. You have to revisit your business structure because as the business grows, the structure has to grow with it. So those are the conversations that we have, and that's the mission that we're on, to help entrepreneurs understand business structure. There are some things that you can do for yourself. And after practicing law for many years and encountering so many different people, and even representing myself as an investor, but observing so many people find themselves in unnecessary, precarious situations, things that could have been avoided merely because they didn't know, or if they knew, they decided to forego and maybe come back later. I've heard that so many times. Oh, I'll come back when the business starts making money. Don't worry. I'll circle back. And usually what happens is that you get caught up, or the business owner gets caught up in the grind, and the circle back is imposed upon them by being served with the lawsuit. Now it's too late. Because once that happens, there's nothing that you can do to protect your assets at that point. It's like everything is frozen in time. So that was the beginning, is the absolute best time to structure. The next best time to structure is right now, before you find yourself embroiled in conflict. It's the best time. And I would invite you to take a look. If you're operating a business right now, we've created a free resource for the operators. Take a look at how you're operating your business. It's called the Structural Exposure Check. The link is in the description. Okay? Takes about 5 minutes to take. It's going to ask you questions in 5 different arenas based upon how you operate the business. There's nothing personal there. Asking questions about how you operate the business, and it's going to provide you with a risk score, letting you know whether or not you have exposure on the ownership side, the control side, risk, assets, continuity. Those are the 5 areas, because that's the first step to see where the leaks are, where the exposure is. Not to run out and start grabbing documents and trying to figure out where can I get a document to start a trust, or how do I start a holding company. That's not it. That's one of the most common mistakes. People, business owners, thinking that paperwork solves the problem. But if you don't know how to operate, you're just going to show up at court or wherever with a bunch of paperwork, and all the answers to the questions are going to be improper. That's the part. That's the point. Understanding how to operate. And that takes me back to this point. Over my 30 plus years as an attorney representing business owners, right? I've met a bevy of people, intelligent people, hardworking, grinding people, all kinds of capacities. And I've met also a lot of people who want to do for themselves. I call them the self-reliant entrepreneurs. As a matter of fact, those individuals were the inspiration for free law school. People who want to do things for themselves. I call them the pro sepreneurs. You may be familiar with the Latin phrase pro se. Most people associate it with someone who represents his or herself in court. But the meaning of the word is for oneself. That's what pro se means. For oneself. And we all know who the entrepreneur is: business owner, person who works for his or herself. So the pro sepreneur is a term that I coined. The pro sepreneur. That's the business owner who chooses to take responsibility for his or her own structural literacy and understanding how to operate in the business and legal environment. And that's something within many people's power, with some guidance, with the right guidance. And again, that's the mission of Free Law School. That's what we're doing here. Working with those self-reliant entrepreneurs who want to understand how to operate. Because look, most people, many of you guys, if you've engaged with lawyers before, counsel, and this is not to say that you should not have a relationship with an attorney in your jurisdiction. Everyone should. Because we're talking about putting structure together. Structure will not prevent someone from filing a lawsuit against you. It's going to happen. But when you take your documents, your structure to that consultation with the attorney in your jurisdiction, they're going to understand that they're dealing with a different type of potential client. You didn't just come there in a panic with absolutely nothing, wanting to defend against a contract default, but you don't even have a copy of the contract. There was no contract. It was a handshake. Or as a previous client once said to me, Greg, we did it on the strength. On the strength. And so that's the pro sepreneur, the business person who wants to understand. Because again, most of the time, the operator, founder, entrepreneur, whatever, engages the attorney to create a contract, review a contract, form an entity, whatever the business call was. Sure. And in a week or two, you go to the office and you pick up those documents, or they're sent to you digitally or whatever. That's what I call outsourcing your understanding. But when you get back to the field, when you get back to the office, yeah, you have those things that the attorney produced for you, but you're still no closer to understanding how to operate. He doesn't come to the business with you, to the office with you. To advise you on how to sign, when not to sign, what to sign, how to move money. What does a draw look like? How should you take a distribution? How should you sweep the money up from the operating LLC up into the holding company for safekeeping? We need to understand those things for ourselves. And those are the kind of conversations that we're having. And so again, the link in the bio, the structural exposure check, it asks you questions across those 5 arenas: ownership, control, authority, risk, assets, and continuity. Authority and assets are in the same category. But when you answer those questions, you want to answer them truthfully based upon how you actually operate, because that's the only way you're going to get a real score or a real answer and a glimpse into where your structure may be deficient. Those are the issues. Those are the things that we need to understand. It's a lot on the line. Your family legacy. What happens if you're operating the business? What happens if you have to step away for a month or two? Does the business operate? Does the business continue to deliver goods and services? Is there a written authority on who can do what and how in the event that you're not there? What happens if it's something greater than incapacity? What happens upon death? Does the business go through probate? Or all of your assets frozen? Is the family stuck out and waiting for 18 or 24 months? And remember this, when we're talking about continuity and probate and estate planning, that 18 to 24-month process at the courthouse, all so that the court can decide. The court maintains a status quo. That's what probate really is. It's about a status quo, about holding things, freezing things right where they are until such time that the court determines who has the authority, who's supposed to receive what. Now, picture this: 18 months for someone else to decide who has the authority or control to move what you left behind. When you can make those determinations or that determination right now and create the authority right now in writing, such that whether it's incapacity or death, nothing stops. Nothing stops. That's what the trust does. That's the purpose of the trust, to establish the continuation of authority, to establish who the beneficial owners are. All of these things are done in advance, and they take effect in advance. That's one of the biggest differences. That's the greatest difference between the trust and the will. The will only takes effect upon death, and then you still got to go through the process of probate. The trust, inter vivos, while living, takes effect while living, immediately. You sign the trust agreement, and then you fund the trust by transferring those assets into the trust. And when we combine the trust with the holding company and the operating company, we create some asset protection from lawsuits, all of those things. And so, again, the structural exposure check is there. The link is also there. If you want to talk to me about any of these things, there's a link in the profile where you can schedule a clarity call. We can talk about these things. We can talk about anonymity, about setting up your LLC, holding company, and trust such that you create invisibility, making it harder for people to find you in the event that there are claims or liability. Because remember this, when something happens, the attorneys on the other side, when they're doing their investigation and due diligence, they're looking for your assets. And that's how they determine whether or not they're going to actually file a suit. If they can't find anything, then in many instances, they're going to accept what the insurance company tenders. But if they can go, there are a couple of websites that the attorneys use, and they can go there and they can put the name of your LLC in, put your name in. They can put your name in, and it's going to populate and tell them about all of the LLCs or businesses that you own. And with that, they can begin moving, looking for assets in the particular jurisdictions, real estate holdings, on down to Office of Motor Vehicles. But it's within your power to create invisibility. But you have to know, that it's possible and how to go about doing it. There's an order and a sequence to accomplishing this. And again, the structural exposure check is there for you. If you determine after taking the structural exposure check that there is some exposure there, and you want to talk about how to go about mapping out your exposure and creating a plan for eliminating that exposure and creating some anonymity, then schedule a clarity call. The link is in the profile. I appreciate you guys joining the live this evening, and we'll get together on another live. I hope you enjoy the rest of your evening.